Hello, I'm Paul Laney, the retired sheriff from Cass County, North Dakota, and the current vice president of national sales here at Turnkey Corrections.
And I'm Lauren Matthews, and I'm the current social media and content specialist for Turnkey.
And you are listening to JailTalk. And if you like what we've been doing, give us a little follow on YouTube. Give us a like, as well. We certainly love your support. And just want to give a shout out to all the law enforcement officers out there. Thank you for everything you guys are doing. It's been a real trying time lately. In the last 5 days, we have had 4 officers go down. And it breaks all of our hearts. And we just, from JailTalk, want to say we're thinking of all of you. And you know we're always in your corner. Well, Lauren, we have been on the road.
We have.
This is home. We haven't been home for a while.
I kind of forgot what it looks like.
And it feels funny to be back here, but it's good to be home. And it's really good to be having the guys sitting beside us here today.
Yes.
We have a very impressive man sitting here. His background and his knowledge, he's forgot more than most of us will ever know about liabilities. We have with us the General Counsel for the Minnesota Sheriff's Association and a whole lot of other hats that you wear. Rick Hodsdon. Rick, thank you for joining us on JailTalk today.
Absolutely, and I was glad to be able to sneak across the border from good old Minnesota over here and didn't get stopped at too many checkpoints. So it's nice to be here.
Those Wisconsin nights, they run some interference on us Minnesota people, don't they?
Right.
Well, they make sure we're not going to bring the spotted cow back.
Exactly. Always thinking like a legal guy, aren't you?
Yeah, got to.
That's good. So, well, it's really, really good to have you here. We're really excited. Just as you know, we always try to have our Jail Talk episodes have a purpose, so that our jail administrators, our sheriffs, those that are out there, our jail staffs, our sheriff's office staff, turn around and go, I'm a better, I got better knowledge, I got a better understanding of something, or I can go back and make my department better for listening to the guests that they had on the show. And having you here, you and I have talked a number of times as we've crossed paths about just getting on your busy schedule and getting you here because you're a plethora of knowledge. When I say you forgot more than most of us know, I mean you have forgot more than most of us know. That's not even a cliche. That's the truth. And just excited to kind of extract some information from you today. So
that might just mean I'm old. I'm not sure.
Well, that kind of goes along with it. We get that knowledge by getting older, and you're kind of stuck with that.
Yeah, I think it also has to do with the fact that you have a very lengthy and impressive bio. So can you go ahead and tell all of our listeners a little bit about yourself?
Sure. I'll give you the short version. Otherwise, it'll take the whole time we've got allocated today if you go way back. I one of those guys that decided to become a lawyer early on, so I graduated high school when I was 17, college when I was 20, law school when I was 23, and I was trying first-degree murder cases at the age of 24, 25 for the state attorney general's office. In addition to that, I've been 33-plus years. I retired last summer from the Washington County Attorney's Office in Stillwater, Minnesota. And I've been general counsel part-time and still am since 1986 for the Minnesota Sheriff's Association. That's where I first met Paul through the National Sheriff's Association. So I admitted to the Minnesota Supreme Court, the District Courts of Minnesota, the 8th Circuit, the U.S. Supreme Court. Besides my law degree that I got from the University of Minnesota, I got a master's degree in public administration from Hamline University. So I try and mix the legal and the practical world, and I study these issues a lot. I teach for Northwestern University's School of Police Staff and Command, teach for MnSCU, and do whatever else I think is fun and important. My wife says she's going to put my face on a milk carton some days. Doesn't see me that often sometimes, but...
Well, I tell her tell June I owe her one for letting you come over and join us today. We appreciate it. We definitely know how valuable your time is. Having been a graduate of the School Staff Command, I was class 137, the very last class of the 1900s. I graduated in December, and I know the quality of instructors they have there. And the fact that you're on staff there says a lot. And on top of that, you teach for the National Staff Command College. You're just a kind of a busy guy. You said you retired from the Washington County District Attorney's Office. Do you know the meaning of the word retired?
My kids always joke saying, Dad, if and when you ever retired from that job, you basically cut back to one full-time job then, right? So I think they knew me better, or they know me better than I realized. That pretty much summarizes it.
Well, we are pretty excited to have you today, and obviously a hot topic all the time in the law enforcement and corrections environment is civil liability. And, every time we don those uniforms, we have a lot of rules to follow. We have this thing called the Constitution of the United States of America. And we have a lot on our shoulders and a lot of things that we have to do. And civil liability is part of something we do every day. And lawsuits within the sheriff's office or within the corrections environment are something that are a reality for us every day. And we're going to pick at his brain a little bit here. Not only this episode, the next episode, we are going to do a part 1 and a part 2 here with Rick, and we're going to talk civil liabilities mostly in the jail environment. But I think a lot of what you talk about really carries over to the law enforcement world. And
absolutely, they bleed over back and forth all the time.
So let me ask you this: for our average listener, or for our law enforcement listeners, what is civil liability? When you hear the term civil liability, what is that?
Well, we tend to think in criminal justice and our legal system dichotomy there's something. We talk about criminal liability, people being prosecuted, as has happened for law enforcement officers, has happened recently in Minneapolis, and there's still cases pending. The civil liability is the money side of it. There are different theories of civil liability, especially that relate to criminal justice. There are 1983 actions, civil rights liability cases. There's also simple civil cases of negligence that did something that a reasonable person wouldn't do and somebody got hurt. So the civil liability can take on a variety of forms, and there's a lot of discussion now at the national level in the so-called police reform movement. So far, a lot of that has been focused on cops on the street and things we'll talk about a little bit in this session, and even more so in the next session, things like qualified immunity, deliberate indifference, legislative efforts to essentially make it easier to sue law enforcement and to sue law enforcement supervisors and officers, people who work in jails, people who work on the street, investigators, their employers, and cities and counties they work for. And so civil liability takes on a variety of different forms and formats and different theories of liability.
So you very briefly said 1983 action. So can you go into what that actually is? Because I know it wasn't that long ago, but I wasn't even born yet. So,
well,
I think we just got dated again. I think we just got old again.
Even more so. 1983 is not named after the year. It's named after the provision of the federal code. It's found in 42 U.S.C. 1983. If we were going to use the date of enactment, we actually should call them 1871 because the Civil Rights Act was part of the Reconstruction era as the Northern armies, or my Southern friends say the armies of Northern aggression.
Yes, they do say that.
Left the South during subsequent to the Civil War. Congress at that time was concerned that many of the gains that had been made in terms of the 13th, 14th, 15th Amendment, freeing slaves, were essentially going to be reinstitutionalized, and ultimately they were right in many situations. For years we had Jim Crow laws, separate but equal, supposedly, Plessy versus Ferguson, all that case law. But as part of a series of legislation, Congress adopted, they called it actually the Anti-Ku Klux Klan Acts of 1871. And the theory of a 1983 action was to give a civil remedy to victims of constitutional violations. And so Congress enacted that law. It has never been changed. If you read the full text of the act, you go, this is kind of odd language. Well, that's because people talked and wrote differently back in 1871 than we do in the modern era. And so essentially, civil rights actions are intended to give people who are victims of constitutional violations by government officials a civil remedy. And that civil remedy can take the form of a civil lawsuit for damages. There's for example, two individuals were held liable and affirmed by the Court of Appeals out of the Sixth Circuit, which is the Ohio area, for a total of $26 million and $24 million apiece for violating somebody's civil constitutional rights in a jail context. They were sued for punitive as well as compensatory damages, and I'll talk about what each of those are later. And then that's just one option. Another use of 1983 actions or civil rights cases is for injunctive relief. If you go back to the late 70s, early 1980s, you'll find an era where a lot of jail and prison reform took place. At one point, over two-thirds of the states of the United States had part of the correctional system under some kind of federal mandate or court order. And prison reform groups would file civil lawsuits contending that the condition of confinement in jail or prison were constitutional violation, terrible food, physical abuse, terrible physical plant issues, for example. And so they would file a lawsuit on behalf of the current or future inmates, and the judges would order on a constitutional basis a change and say, this is what you have to do from now on. You have to provide medical care, for example. California is a good example. In the modern era, the California penal system, the correctional system, is still under a major court order as to how they deliver medical services to inmates. So the civil liability can take the form of damages, and it can take the form of injunctive relief, or both.
When I'm sitting back and I'm thinking of my times as sheriff and all those times that, in my facility, we had a 348-bed jail. So you think about this, 348 potential civil cases or more sitting in there. When I put myself back in those shoes, and having been in those shoes, and with our jail administrators, our people out there, you talk about, and it would really resonate with me when you said this, what you talked about back in 1871 and what all happened as times went on and all that really rings true today, doesn't it? I mean, don't think that because this was all back then. Really, every time we walk inside those doors, we need to be thinking about this type of stuff, don't we? I mean, why is it so important for sheriffs and jail administrators to not put something like this on the back burner? Why is it so important that they tune in and really take a hard look at themselves?
Well, actually, if you go back in history, and there are scholars that are way smarter people than me that have tried to research the history of civil rights cases, and for the first, until the 1950s, 1960s, 1970s, 1983 actions weren't really used all that much in any part of lawsuits against the government. So they were on the books, but not used a great deal. That has changed drastically since the 1960s and 1970s. 1983 action civil rights cases, and now to a growing degree negligence cases, as people have recognized corrections as a profession. Now, you don't get sued for negligence anymore. You get sued for malpractice. If that sounds more sophisticated and fun, you can go home and tell them, I got sued for malpractice today. You're still going to get sued, but at least it sounds
call it what you want. It's still about to be a really bad day.
Yeah, it is. And why it's important is, literally there are tens of thousands of civil lawsuits, 1983 actions filed across the United States every year relative to jails and prisons and issues relative to corrections. And I want to emphasize, for those of you who may not be directly involved in law enforcement, criminal justice, who are watching, if you are a government official, you can be sued for a 1983 action simply by virtue of being a government official. In fact, one of the most important United States Supreme Court cases ever decided is called, it's the Monell case. And you hear lawyers talk about 1983 actions. They talk about Monell, and that ruling held that a government entity, as well as the officials, can be sued as well. And what people forget about Monell is it didn't involve law enforcement. It didn't involve jails, corrections. It involved the Department of Social Services of the city of New York as a 1983 defendant. So any government individual, any government entity can be sued in a 1983 action. And what a plaintiff has to prove for a 1983 action, it's pretty simple, essential elements. The first thing they have to prove is that the person they are suing, or the entity they are suing, acted under the color of law. The second thing they have to show is that they had a violation of their constitutional rights as defined by the Constitution. And then the third thing they have to show is either they suffered some kind of damages, and those could be, pretty low, mental anguish and suffering, no physical injury whatsoever. But if you could show some kind of damages you can collect, or if you can prove for the injunctive relief that going forward, if the courts don't intervene, your constitutional rights continue to risk being violated, you can prevail. So those are pretty easy cases. In the jail and corrections context, almost the easiest case ever, and even on the cops on the street, the easiest part of any 1983 action is to prove acting under color of law. If you're doing anything in your official capacity whatsoever,
Right.
If you're on duty, it's even if you're breaking the law, you're committing a crime. You're assaulting an inmate, for example, without legal justification to use force. Clearly, you're violating policies, procedures, the criminal law. You can be criminally prosecuted. And the fact that you're violating policies and procedures isn't a defense. That may help the organization keep from itself from being sued. And if you're a supervisor, as we'll discuss in a bit here, you can be liable for the errors and omissions and sins of your subordinates. So color of law is a pretty easy case to make almost every single time. The bigger question is, did you violate somebody's constitutional rights? And 1983 actions are different than the state tort claim cases for negligence, because if you do something wrong, you breach professional standards, you could be liable for negligence, like legal malpractice or medical malpractice, or just driving down the road and blowing through a stop sign and smashing into somebody. That's a simple negligence case. But you won't be liable in a 1983 case. So you have to find a constitutional right that has been violated, and as we'll discuss, that's where these cases hinge on. Did the defendant or the person being sued or the entity being sued violate a clearly established constitutional principle? And like I say, the damage issues are pretty easy cases to make. If you suffered physical pain, injury, loss of income, anything like that is enough to ring the bell. And the damage question for 1983 cases, and what is the pucker factor you describe for a jail administrator, is the United States Supreme Court. There's two kinds of damages. There's compensatory damages and there's punitive damages. And compensatory damages are intended to make the injured person whole. So go back to my negligent car crash case that I just mentioned a moment ago. You got your leg broken, you had medical bills, your car got wrecked, you lost income. You add all that up and put a price tag on it, and that's compensatory damages. The second kind of damages are punitive damages. And the Supreme Court of the United States has ruled because to prevail in a 1983 action, a plaintiff has to show reckless, wanton, willful misconduct, or deliberate indifference is a term you hear a lot. The Supreme Court has said if you meet the threshold for compensatory damages, then you also met the threshold to get an award of punitive damages. So that case I mentioned a few minutes ago about the $24 and the $26 million, a vast majority of those verdicts were for punitive damages. Two officers essentially beat an inmate to death and then covered it up. And so the jury awarded in excess of $20 million punitive damages for each of those. So that's the scary part from a liability standpoint. And for 1983, the other scary part that makes a lot of risk managers extremely nervous is if you lose a 1983 case at trial, there's a provision of 42 U.S.C. 1988 that's the real ticking time bomb here. And what that does is, in a typical negligence case, if I sued you for my car crash example, and a case went to trial and the jury awarded you $100,000, you don't get $100,000 because your lawyer's going to get a third or some places 40% of that. In a 1983 case, Congress created a special fee-shifting statute. So in a 1983 case, if you go to trial and you're a plaintiff and you prevail, after you get your, in my example, $100,000, that's not all the defense has to pay. Now the attorney for the plaintiff goes back to court, submits their time records, and the judge determines how much time they reasonably spent on the case, and then determines in that federal judicial district what the appropriate hourly rate is, and then the defendant has to pay not only the damages, but the attorney's fees as well. And it's not at all uncommon for the attorney's fees in many of these cases to far exceed the actual damage award to the injured plaintiff or party. So, for example, in Minnesota,
you lawyers are expensive.
We are.
Very expensive.
More than you probably realize. In Minnesota, about a year or so before I retired from the county, there was a case about to trial, and the lawyer ended up with 2 or 3 times as much in attorney's fees as the plaintiff, who successfully sued and went to trial. And the federal district judge in Minnesota said, for an experienced civil rights litigator, an appropriate hourly rate is $700 an hour. I took that case and I did give it to my county administrator, pointing out that I was an experienced civil rights litigator, but I never did get a raise. So I'm not sure. Not sure.
It was a good try, though. Welcome to public service, right, bud?
Exactly. So it's that's why we have to worry about that.
And I think that's what's I'm really excited about part 2 coming soon is that you're going to get more into this. What does constitute like a deliberate indifference? What does constitute that negligence? Because I know you're all probably like me, kind of going, okay, what is that? So I can make sure we don't do that. And I assure you, tune back into part 2, you're going to hear this. Lauren, I know you had a question about a little bit about what happens if, and I think he's going to hit a lot of that next time. But I think we should touch on it today because I think it's a good question.
Yeah. So I mean, you kind of asked the question, but basically, what happens if someone finds that they have violated this?
Okay. If a plaintiff believes that they have a constitutional claim, they have 2 options. One is to try and find a lawyer that agrees with them. And frankly, that's one of the reasons Congress enacted the attorney's fee statute, because many times you think about, okay, there was a constitutional violation. What's that worth? Lawyers are always thinking about the bottom line, as Paul says, the money part of it. So let's say that I'm an inmate in a jail, and I have a attorney-client privilege, and so a letter from my lawyer comes in, but a jail staff member either intentionally or accidentally opens it and reviews it. So what? How does that, car crashes and broken bodies and injuries, that we can put a price tag on. But how do you put a price tag on somebody read my mail? And they shouldn't have, because they violated my 6th Amendment right to access to the courts or attorney-client. And so a lot of lawyers would say, I'm not going to take that case because it's not worth anything. But now Congress has given those lawyers an incentive to take it. Okay, so you get literally, we call these $1 verdicts. The plaintiff gets $1 for their damages, and the lawyer maybe gets $100,000 of attorney's fees. But the other possibility is if I can't find a lawyer or one will work for me, in thousands and thousands of these cases in jails and prisons are filed every year, the people represent themselves. They act pro se. Or pro per is what some jurisdictions call it, but they essentially represent themselves, which they're entitled to do. And the federal courts, historically, especially dealing with jails and prisons, have cut those people a lot of slack. Things that would get a case thrown out of court. If a lawyer did it, a lot of times the judges will just kind of look the other way and say, well, this is a lay person. They may have a claim with merit. Let's go ahead and let them proceed. Now, that's led to a lot of abuses, and Congress adopted, in an effort to try and balance that, years ago adopted what's known as the Prison Litigation Reform Act. And the Prison Litigation Reform Act has procedural requirements to try and reduce frivolous nonsense lawsuits. And to a large degree, it's worked. The feds contend in some research that there are probably 5,000 fewer lawsuits filed every year involving jails and prisons because of the Prison Litigation Reform Act. But one of the big utilities, and why I want to encourage, by now I hope everybody does, every jail, every prison has implemented a system. The Prison Litigation Reform Act has a mandate. If you want to file a lawsuit, either through a lawyer or on your own, relative to conditions of confinement for the jail or the prison you're in, if that facility has an inmate grievance system, you are statutorily mandated to exhaust all available remedies through the grievance system. So one of the best ways, one of the big major ways that a jail can really reduce their risk of liability exposure for 1983 related cases is to have a viable, effective grievance system. If the listeners here take nothing more away from this whole discussion we're having in this part and part 2, having effective, viable, documented grievance system is a major defense mechanism to reduce those kind of what-ifs. Because if the person just simply goes into federal court, files a lawsuit, one of the questions the federal judge is going to ask is there a grievance system in place? Did you use it? And if the answer is yes, there is, no, I didn't, bang, the case is literally gone out the door. Now, there's other collateral advantages because sometimes we do make mistakes. And if we've given inmates, prisoners a viable grievance system, you lost my mail, you lost my book, you didn't let my boyfriend, girlfriend, whatever, come visit me wrongfully, whatever. You address that, you can head a lot of these issues off at the pass, because if you fix it, they could potentially still file that civil rights suit. But now what are their damages? The damages now are virtually zero because they had a legitimate beef. You addressed it, you fixed it, and it's going to prevent a lot of lawsuits. So that's how it plays out. They'll file in federal district court, typically of where they're being held or where the incident took place, and then the litigation, the expensive, pricey part starts after that. So if you can head these cases off at the pass by an effective grievance system, you're doing your job as an administrator, whether it's a sheriff, a prison warden, a jail administrator.
Well, great information right there. Just that alone, I think, as we said, our goal with this is for our law enforcement, our sheriffs, our correctional staff to go back and make some changes or make some things better. And I remember my grievance system well, and yes, it was a pain in the butt sometimes, and we were very thorough with our system. But to hear what you said made me feel good about what we did there and how we did it, because we definitely had an intense one. And yeah, was it a pain in the butt for me sometimes as a sheriff to have to answer something might seem trivial from an inmate, but if I didn't, I did realize the repercussions if I didn't follow that. So excellent advice. Having been in that situation in the past, I can tell you it does matter. And I think, most of you out there, experienced listeners, probably are agreeing that yes. And if you don't have that system, I strongly recommend you take a hard look at what you have lacking and shore that up, because that's the kind of ways we protect ourselves and we protect our agencies from exactly that. And in part 2, we're going to dive more into what are some of those violations and how do they happen. So, Rick, like I said, I was so excited to have you come on, because as I told you when we first sat down and started talking about scripts and questions and all that, is like, it isn't going to be what are we going to talk about, it's how are we going to condense enough into a show that we can pick at your brain. And part 1 here has been great foundation laid, and in part 2 we're gonna hit it hard and go back more into what are some of these violations and how to protect yourself better for them. So tune in then. So do your spiel.
Well, thank you everyone for tuning in. Make sure you subscribe to our YouTube channel, follow us on Twitter and Instagram, or email us at jailtalkpodcast@gmail.com.
Well, thank you all for joining in. I'm Paul Laney.
And I'm Lauren Matthews.
You've been listening to Jail Talk, and we'll see you at part 2 next time.